Rocky Balboa Aurelius III, you stand before this court, accused of aggravated licking, cuddleduggery, heart thievery, and being just too cute. How do you plead?
Obviously, you wouldn't put a dog on trial for a crime, right? What if I told you that in Europe, as early as the 9th century, possibly even earlier, and as late as the 20th century in the United States of America, trials against animals are a well-documented fact? A pig in France being tried, tortured, and hanged for the killing of a child. A group of moles in Italy being excommunicated from the church for the destruction of crops. A rooster being put to death for the crime of having laid an egg. These are all trials that actually happened. Attorneys argued on them. Judges passed down sentences, like on Law & Order, but with animals. To us, this idea may seem ridiculous, for reasons we'll get into later. But for now, let's dive headfirst into the world of animal trials. First, it's important to understand that there wasn't just one type of animal trial. In his works on the subject, German law professor Karl von Amara divided animal trials into two distinct classifications, Tierstrafen and Tierprozesse. Roast me in the comments, Germans. Rocky won't stop barking, so he's going to come record with me. Tierstrafen refers to secular criminal trials against animals accused of homicide, which I'm going to talk about last because, being secular in nature, they're what conflicts most with our current understanding of animals in the justice system. Tierprozesse, on the other hand, were ecclesiastical, put on by the Christian church, and were generally against masses of animals like rats, locusts, the aforementioned moles, for destruction of crops or other nuisances among the people. The lead-up and execution of these ecclesiastical trials could be said to go something like this. The complainant, guess what they do? Perhaps a farmer with his crops being destroyed by locusts files a complaint with the ecclesiastical court, who orders an investigation to assess the damage and the root cause thereof. If the court investigators find the damage significant enough for proceedings, they'll first tell the local populace to make processions and pray for deliverance from their predicament. If the thoughts and prayers work, which they always do, great. God has answered the prayers of his flock. If the thoughts and prayers don't do anything, unlikely, the court would issue a summons to the offending animals and appoint a defending attorney. Hey, a swarm of locusts. Come to court on July 1st. Your defense attorney will be waiting. It would be easy to assume that these appointed defense attorneys just did a little song and dance for the church court. But no, many of them went through rigorous defense tactics for their clients, just like defense attorneys today still do. They would do things like file motions to delay the trial, claim the court didn't have jurisdiction and request dismissal of all charges, and if all the standard defense tactics didn't work, they would mount a case to absolve their client. For example, one of the most famous animal defense litigators in history, weird title, but it's accurate, he's even got a movie based on his life, Barthélemy de Chasseneux, was appointed to defend the rats in the province surrounding the French city of Autun, who had been destroying the barley crops in the area. The trial took place in Autun itself, but all of the rats in the surrounding area were accused of the crime and summoned. Chasseneux noticed that the summons had only been issued in a single town, and argued that all of the rats in all of the villages of the surrounding area couldn't be reasonably expected to have seen that citation. The court agreed and issued a second summons in all the surrounding townships. When the furry fugitive still failed to show up in court, Chasseneux had another argument up his sleeve. The counselor claimed that the rats would have to come from far and wide in order to appear in court, and that in their travels they would be under grave peril from their natural enemies, the cats, or les chiens. He said it was unreasonable to expect a defendant to risk death in order to answer a court summons. Sounds like a lot of trouble to go through for a bunch of rats, but as far as I can tell, it worked. The court suspended the trial indefinitely, and the rats were never sentenced. Of course, tactics like these didn't always work. While sometimes a small collection of the animals would be brought into court to satisfy habeas corpus for the trial, like a jar of locusts being put on a desk or something, almost universally, the pests would not obey their summons and fail to appear in court, which would result in them losing by default. Similar to, say, a civil case in the U.S. today, where if the defendant fails to respond to the suit or show up in court after a certain amount of time and notices, the court will issue a judgment against them. After they lost the case, the animals would suffer the anathema, a curse of sorts uttered by the church that would excommunicate the animals or invoke God's wrath against them. Those of you with knowledge of church doctrine may raise an eyebrow at animals being excommunicated, as they can't actually be members of the church in the first place, but think of it more as a removal of God's protection from the animals. So why do all this? Why would the church entertain these complaints, much less go through these formal proceedings? The church was an immensely powerful organization during this time. Its hold over the people was strong, and they would go to them for redress of grievances and protection, especially from threats that appear to be outside of the realm of human control. A plague of rats or a swarm of locusts may have been seen as acting at the behest of the adversary, and the church were the only ones equipped to combat such a threat. The church could invoke the anathema, sure, but all of the formal proceedings had to be followed. They were parts of the ritual invoking the aid of God. If all the steps weren't followed, the ritual would be broken and the curse wouldn't work. Besides all that, it was a win-win situation for the church. If at any step during the formal proceedings the animals died mysteriously or they all vacated the area, the church could take credit. If even the anathema didn't work, they could claim the pestilence was punishment from God for the sins of the people. And as you know, the cure for that is to follow the church's rules harder. Go to Sunday service, and you best be up in your tithes. We still see behavior of that sort from less savory religious characters today, of course. Like back in 2005 when televangelist Rick Joyner claimed that Hurricane Katrina was punishment against New Orleans for a large pride celebration they had planned. Hey Rick, go to hell. Moving away from the church, but only so much, let's take a look at those secular criminal animal trials. I don't have a lot to say about these animal homicide trials procedurally. They would occur much like the trials of murderous humans, which can lead to several humorous thoughts if one were to say, imagine a homicidal pig being found, taken into custody by the sheriff, jailed alongside human criminals, tried by a court, and executed. Okay, the last one isn't all that funny, but it's certainly fascinating. Invoking God's justice on a plague of bugs is one thing, but holding a domestic animal criminally culpable for murder? It just seems too far-fetched. What would possibly lead people to do such a thing? Swiss jurist Edward Ossenbruggen argued that only humans can commit crimes, and so only through personifying animals can we hold them criminally liable for their actions. This seems mostly in line with the way the legal system treats animals today, so what caused people in the past to hold animals criminally culpable like people? One explanation may lie in the concept of the Wehrgild. The Wehrgild was a sort of restorative justice in Old Frankish law, in which a sum of gold, grain, or other property was paid to a man to make up for the killing of one of his family members. This often extended to anyone who fell under the legal protection of the man, like serfs in his employ, or even domestic animals he owned. In similar fashion to the Wehrgild, an old Welsh law stated that in order to atone for the killing of a dog or a cat owned by another man, you had to hang that animal by the tail, then pour grain over the dead body of the animal until it was completely covered. That amount of grain was then paid to the wrong party for atonement. Basically, the idea was that with this legal protection afforded to them by their owner, also came the legal responsibility of any actions perpetrated by the animals. Another possible motive for these trials was that of deterrence. After all, if word spread through the animal community that one of their brethren had been executed for a crime against a man, wouldn't they think twice before committing such an act themselves? There's one final reason that could have led to these trials, and it's the idea of preventing an invitation to evil. The ancient Greeks believed that if a murder was committed and not properly addressed, that is to say the culprit was not found and punished, that the Furies, fearsome deities of vengeance, would be angered and sow pestilence and destruction across the land. Similar sentiment appears in the Old Testament of the Bible, in the famous Exodus verse, "You shall not suffer the witch to live." You see, animal trials and the burning of witches at the stake share close origins. Humans have long held the strong belief that evil should not be allowed to take root, that not a single foothold should be given to the dark powers of the world, lest they overtake us. But when this idea is misdirected, we can find ourselves responsible for any number of atrocities. Luckily, we, in our enlightened modern sensibilities, would never do anything as silly or barbaric as putting an animal on trial for murder, especially in the United States. In 1924, a Labrador retriever named Pep was accused of killing the pet cat of Pennsylvania Governor Gifford Pinchot. The dog was tried for the killing in a proceeding led by Pinchot himself. Unsurprisingly, given the judge, the dog was found guilty and sentenced to life in prison. Pep spent the rest of his days in Pennsylvania State Penitentiary, where he died 6 years later. Yes, that was a century ago, but vicious animals are still put down today, often at the order of judges, albeit without the benefit of a trial. Our society has, in general, a shared understanding that because they lack moral agency, that is to say, the ability to tell right from wrong and act in accordance with or in opposition to that knowledge, animals cannot be held morally or criminally responsible for their actions. Because our society, in general, also views animals as lesser than humans, animals likewise do not benefit from the rights we're supposed to enjoy, and can be put to death in the name of public safety or even just overpopulation, with a very small burden of proof and very minor or even no official proceedings. Even animal cruelty laws are typically classified as crimes against the owner of the animal or society at large, and animals are very rarely listed as the actual legal victim of the crime. The purpose of a trial, ideally, is to separate the accuser and those passionate about and involved in a case from the legal proceedings and ultimately the end result of a sentence, to ensure that objective facts and proof are the governing force in determining guilt. But when superstition, fear, corruption, vengeance, or just simply the darker aspects of human nature are allowed to drive the vehicle of justice, justice itself becomes a joke. Nothing more than a poor excuse to justify the whims of bad actors, and to diffuse the responsibility of a few to society at large, or to the process. And just like Pontius Pilate, those few then claim their hands are clean as they hand over a life to the mob. Thank you so much for watching, and I will see you next time.